Good morning. Today I'd like to talk a little bit about litigation. Let me give you a great example of a case to tell you the kinds of things that you need to watch out for as an individual or a business who might be in litigation. Let's just suppose that you are sued and you receive a complaint and a summons and it's served on you. So you know about the case. Maybe somebody sues you for $1 million and you feel that that's an outrageous amount. You feel you did nothing wrong and you're very distressed about that. But you're busy. You've got a lot going on. And so instead of doing anything at that point, you just stick all that paperwork in a drawer and procrastinate or forget about it and hope it'll go away. Well, unfortunately, that could be a $1 million mistake. So we're going to talk about why those types of things matter and why you need to have some knowledge about procedural law so that then you will be a much better business person and much better prepared as an individual to survive if there is litigation, and most of us end up at some point or another being touched by this issue. What we're going to talk about today is procedural law, and it's going to be primarily about civil cases, cases where a plaintiff sues a defendant for money or for some other relief. It's not so much about criminal cases. We're going to talk about the various stages of a lawsuit. We're going to talk about what happens if you don't answer a summons and complaint in a timely manner. And you're going to talk about the different types of attorney's fees. Now, when you go to court, you're going to start out as a plaintiff with filing a complaint, which sets forth the grounds for your lawsuit. And that will be served on the defendant with a summons that tells the defendant, you have to answer this complaint, and here's your time period that you have to answer, and so forth. And so the defendant gets those things, and they have to answer within a short period of time. If they don't do that, there's big trouble. The defendant can also file a counterclaim back against the plaintiff or bring in third-party defendants if they feel like somebody else is at fault. Now, you may not have a trial because in many cases the defendant never answers or they don't answer on time. There's a famous Beach Boys example where they were sued by some temporary bodyguards who were off-duty police officers. The bodyguards accused the Beach Boys of beating them up, and therefore they sued for hundreds of thousands of dollars. The Beach Boys got the complaint summons but ignored it. And because they ignored it and waited several months to pay any attention to it, the off-duty police officers or bodyguards got a huge judgment automatically against the Beach Boys. And the Beach Boys could not later come back to the court and say, I'm sorry, we got confused or we forgot or whatever. They had to pay it. And so that's the issue with default judgment. If you don't answer, there will be a default judgment, and that's not so good. That's a commonplace occurrence in many cases. But also the defendant can come in and say, I want the court to dismiss the case. They can say there's no jurisdiction, for example. Or they can say the plaintiff has failed to state a claim on which relief can be granted. For example, a good example of that would be a lawsuit by a ticket holder to a New England Patriots game. Could, maybe after they find out back in the day that the Patriots cheated in that game somehow, that ticket holder who went to that game might try suing the Patriots, saying, I paid good money for this ticket. This is not right. So I'm suing you. A court's probably going to say that's not really a claim that we want to hear, that legal relief can be granted on. Sometimes there can be motions to dismiss if the plaintiff does not have standing to sue. Suppose I go to Toys R Us, buy a toy for my niece, but I see some other toys there, and I realize one of those toys is very dangerous for children, and it makes me mad. But I don't actually buy the toy, mind you. I just see it, it makes me mad. Well, if I try to sue the toy maker based on that and try to get some damages, court's probably going to kick that out and say that I personally don't have standing to sue. I didn't even buy the toy. So there can be motions to dismiss before there's even a trial. And that saves the court a lot of time if the case court doesn't have jurisdiction, or there's some claim that really isn't going to be held up, even if everything in the complaint is true, then we need to just get it out of the court now, because the courts are bogged down with lots of work to do. So we don't want to waste resources by having any more happen in the case than if it's a case that shouldn't be there. If there's no reason to have a trial, if, in other words, there's really nothing to try, everybody knows what the facts and the law is, then a motion for summary judgment can be also occur before the trial. And so you need to know this terminology, because sometimes you will see some of the cases we'll read in class where some of these motions have been made, and you want to be able to understand what this means and why they're important. So if the defendant says, hey, I want a motion for summary judgment, and it's granted, then the case is over. Although then, of course, the plaintiff could appeal that decision if they feel that there should be a trial. And the Court of Appeals could say, yes, we agree with the plaintiff, and make the lower court then go back and have a trial. So that would be a reversal and remand of what the lower court did. So you need to be aware of that terminology so you'll be comfortable reading court cases and understand why these types of motions are important and why courts of appeals sometimes hear these. Now, one of the things you'll do before trial often is go through something called discovery. That's so everybody can gather facts. You could have a deposition where people come together, and they have a court reporter, and lawyers can ask them questions about the case and go ahead and gather the facts. And that's nice because then you have a permanent record of what people said, and even if the trial is 3 years after the fact, the discovery will be at a time when things are hopefully fresher in people's minds, and go ahead and get that information. The other thing nice about a deposition is after you go through that, the attorneys can weigh if they depose a witness or a party to the trial, they can determine what kind of testimony is this person going to give at trial. Is this a case I want to go forward with, or should I go ahead and try to settle it before it goes to trial based on what I've learned in the deposition? There's also interrogatories, which are also question and answer, but they are in written format instead of the deposition, which is oral. You can do request to produce documents, request for mental and physical examination, which might be common in things, cases about car wrecks and those types of things. So discovery is a very important aspect of the trial process. And sometimes after discovery, people go ahead and settle the case when they learn more about it as they go through these processes. Sometimes, though, the trial will go on. Sometimes there's a pretrial hearing. Then there's jury selection if the parties don't waive their right to jury trial. There's something called voir dire. That's questioning the jury's pool. So someone could ask a juror, are you related to anyone involved in this case? If a person says, hey, the defendant's my brother-in-law, they're going to be sent home. They're not going to be a juror because they have a conflict of interest. There's a recent case of a trial of Vanderbilt football players who were accused of raping a woman, and the jurors were asked lots of questions about their previous experience with that type of thing. One juror did not mention the fact that he had been involved as a victim of a sex crime. And after the trial was over, this came out, and unfortunately, they're going to retry the case. So you can see how a juror can make a big difference. And voir dire is important. It's important for the jurors to be honest, because now this juror has wasted the court's time by not talking about his specific issue or not answering the question completely. and then later giving the defendant's grounds for new trial. Now, after the jurors are questioned, the attorneys have the opportunity to do challenge for cause or peremptory challenge. Now, challenge for cause would be the brother-in-law case. You know, if somebody says, hey, I'm a brother-in-law of one of the defendants or whatever, then the attorney for the prosecutor or the plaintiff could say, Judge, I have a good reason for this person getting off the case, and the judge will agree, and that's a challenge for cause. And those are generally pretty unlimited numbers. Peremptory challenge are just extra people that the attorney may also want to get off. Maybe the attorney feels that I don't want a certain type of person on the jury, maybe a person that's giving me a funny look or whatever, then they will have a limited number of people they can just kick off the jury or to use their what we call peremptory challenge to take off the jury so that, they can just pick some people for no reason. Now, remember, peremptory challenges are not supposed to be used for discriminatory purposes. So it's not supposed to be a case where the attorney says, I don't want people of a certain race on the jury or so forth, although I suspect that does happen. Okay, there's also opening statements then after the jury's selected. And remember, jury selection can take all day or maybe several days in some cases. Then both attorneys have an opportunity to make opening statements for the plaintiff and defendant. Then there's going to be a trial. The plaintiff's case is going to be put on first, where there is testimony. Now, remember, we also are talking about the trial, which is only held in the court of original jurisdiction, the local trial court or the district court if you're in the federal system. We're not talking about the appeal at this point. During the plaintiff's and defendant's case, witnesses will be called to testify. Rules of evidence will be applied, so you may hear attorneys say, objection, Your Honor, that's hearsay, those types of things. And the judge will have to rule on those rules of evidence. The burden of proof is important. Remember, in a civil case, the burden of proof is easier to meet than in a criminal case. So in a civil case, it's usually a preponderance of the evidence that the plaintiff has to prove a case. But there are other variations on that depending on what type of case it is. In a criminal trial, the burden of proof is much harder. It's harder to prosecute and convict because that burden of proof has to be beyond a reasonable doubt. And so sometimes something can be a crime and a tort, and once in a while, someone will be acquitted of the crime because no proof was given, or at least not enough proof beyond a reasonable doubt, but still have to pay for the tort. And that was an example that you've seen in the O.J. Simpson case, where he was acquitted of murder, but later sued for a tort in civil case, and he was held to be liable. And the burden of proof may explain part of that. After that, attorneys can make a motion for directed verdict and say, Judge, we don't even need to go take this to the jury. Just go ahead and direct the verdict now because it's clear what should happen. That's probably pretty rare if there's a jury involved, but it can happen. Then if that is denied, then there's closing arguments. Then the jury gets instructions about what they need to be deciding and what the law is, and then they have time to deliberate. After they deliberate, they come out with a jury verdict and judgment. At that point, an attorney can make a motion for a judgment notwithstanding the verdict. They can say, Judge, I know the jury said so-and-so, but I want to go ahead and say, Judge, that was such a crazy decision by the jury, you need to overturn it by giving a judgment notwithstanding the verdict. If there's some issue where the trial was somehow tainted with unfairness, there can be a motion for new trial. If that's denied, then the case is over, and then there can be an appeal. At the appeal, remember, there's not another jury, not a bunch of witnesses testifying, but it can be an appeal on issues of law. If someone feels that the judge in the case made an error about the law somehow, then there can be an appeal. If there is no appeal, then you go straight to enforcement. You know, if you sue somebody and they don't have any money, and you're trying to get money, You may have to go through enforcement mechanisms. So you sue me for $1 million and I've only got $50 in the bank. What are you going to do? That's going to be a tough one. On the other hand, if you sue me for $1 million, you win, and I only have $50 in the bank, that's bad, but you can also look around and see, do I have land that you could try to take? Or do I have wages you could garnish? Do I have some equipment you could seize? So winning the $1 million verdict is great, but you may also, and the judgment is great, but you may also have to take steps after that to actually collect your money. And so keep in mind that that is an issue. And if you're suing someone who has nothing and has no prospects of getting anything, or if they file bankruptcy after you win your case, you may still be out of luck in most cases. There are exceptions, but to those rules, but there may be issues there. So you have to decide before you go through all this trouble of a trial, is this a defendant that I can, in the end, collect the money from in one way or another? So that's sort of the trial in a nutshell, a really quick tour of the trial. One last thing I do want to mention is attorney's fees and costs. It's really expensive to go to trial, and so if possible, you may try to avoid trial and do some other things. Contingency fee is one way that attorneys can get paid for some cases. So a good example of that would be if you are a plaintiff in a lawsuit and the attorney is willing to take the case without you paying the attorney any money up front. This would be a contingency case. Now, this only works for plaintiffs. Example might be you want to sue somebody in a car accident and you've been paralyzed and you want $10 million. An attorney who feels that's a good case might take that case and they might say, you know, plaintiff, I understand you don't have any money right now, but if we win the $10 million, I want to take a third of it. And you might agree that's fine as a plaintiff because that may be the only way you can get an attorney to take your case. And you need to have that all in writing and very clearly understood. If you are doing something more routine, like maybe a routine bankruptcy that's very small, there might be a flat fee. Usually in litigation, there's not going to be a flat fee, but there could be in some cases. Flat fee would be, hey, I'm going to charge you $1,000 to take care of your case. And sometimes you will see that in routine divorces, routine wills, routine real estate deals. But in bigger business law cases, a lot of times that's less likely. Hourly fee is the third thing that you could have, and that's pretty common in business litigation. If you are a defendant, that may be what you have to do in business litigation. Obviously, contingency isn't going to work because if you're the defendant, the attorney's not going to be able to get a percentage of your recovery because you're not trying to recover anything. You're just trying to escape liability. So you may have to pay your attorney hourly, which could be $200, $300, $400, $500 an hour. So it's a little scary there. You have to watch those fees and ask your attorney to provide regular, maybe monthly bills and itemize what they're doing so you can understand what you're paying. You really do want to have some agreement up front for any case that you end up in with the attorney about how they're charging you and how much the fees are going to be. If you're a plaintiff and you don't have a lot of money to spend, you may go contingency fee route, figuring, well, at least I have 2/3 or whatever percentage is left, and that's the only way I can get an attorney to do it. And it does give the attorney incentive to get you money. But if you're a defendant, you may have to go with hourly fee. And just be aware of those things and watch for it. One nice thing about attorney's fees that I do want to point out is that if you have insurance that covers a situation, the insurance policy may include the payment of the attorney's fees. So keep that in mind. So anyway, that's litigation in a nutshell. There's a lot more we could talk about here, but I did want to just give you a few ideas about how it works, and this should help you in the future as you're reading court cases to understand some of the terminology. I hope you have a great day, and I'll talk to you soon.